Debt verdict, DV020. Title, the $33 settlement from one phone call. Formula, revenge. Duration 9 min. Tags, FDCPA settlement, debt collector harassment, consumer victory. One phone call. That's all it took. One outrageously abusive phone call from a debt collector, and it ended up costing a debt collection agency $33,000. A woman in the Midwest didn't have a team of lawyers. She didn't have deep pockets. She had something better. She knew her rights, she pressed record, and she refused to be intimidated. This is the story of how one woman turned a single act of collector harassment into one of the most satisfying consumer victories in Fair Debt Collection Practices Act history. The Fair Debt Collection Practices Act, the FDCPA, was signed into law by President Jimmy Carter on September 20th, 1977. It went into effect on March 20th, 1978. The law exists for a simple reason. By the late 1970s, the debt collection industry had become a cesspool of abuse. Collectors called debtors at all hours. They threatened violence. They called employers, neighbors, and family members to humiliate people into paying. They used obscene language. They lied about the amounts owed. They impersonated law enforcement officers. Congress decided enough was enough. The FDCPA established clear rules. Debt collectors cannot call before 8 a.m. or after 9 p.m. They cannot use obscene or profane language. They cannot threaten violence or criminal prosecution. They cannot contact third parties about a debt except to locate the debtor. They cannot misrepresent the amount owed. They cannot harass, oppress, or abuse any person in connection with the collection of a debt. The law also gave consumers teeth. Any person who violates the FDCPA is liable for actual damages, statutory damages of up to $1,000 per lawsuit, and, critically, the consumer's attorney's fees and court costs. That last provision is what makes FDCPA cases viable for consumers who can't afford a lawyer. Attorneys take these cases on contingency because they know the collection agency will have to pay their fees if they win. By 2009, the year this story begins, the FDCPA had been on the books for over 30 years. Thousands of cases had been filed under it, but the abuses continued because many collectors believed their targets didn't know the law existed. This woman knew. The details of the underlying debt are secondary to what happened next. What matters is the phone call. In 2009, a woman in the Midwest received a collection call regarding a debt. The specifics of the collector's identity and the exact debt have been partially obscured in public records to protect various parties, but the substance of the call has been widely reported and cited in FDCPA litigation circles. The collector on the phone was not having a good day, or perhaps this was simply how they operated. Either way, what followed was a masterclass in how not to collect a debt. The collector used profane and abusive language. According to court filings and settlement documents, the call included threats, intimidation, and language that would violate virtually every provision of the FDCPA's prohibition on harassment and abuse under Section 806. The collector reportedly made statements designed to humiliate and frighten the borrower. The tone was aggressive, the language was vulgar, and the threats were explicit. But here's what the collector didn't know. She was recording the call. The legality of recording phone calls varies by state. Some states are one-party consent states, meaning only one party to the conversation needs to know the call is being recorded. Other states require all-party consent. She was in a one-party consent jurisdiction, meaning her